Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody, welcome to the show. Thanks for joining us today. Our topic is HOA restrictions on short-term rentals. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like and subscribe to the channel. You can find us on YouTube, and you can find us on Facebook. At YouTube, we are at INREM Podcast. That is at INREM Podcast. With that, we're going to go to Sean, who has our legal update.
Thank you, Andy. So today's legal update deals with subject to purchase contracts, or any purchase or any type of structure whereby you're going to acquire the property or an interest in the property or possessory right in property, and the existing loans are going to remain. And it's going to be your obligation as the buyer and subsequent either fee title owner, vendee under an agreement for sale, or a landlord, or not landlord, tenant under a lease. It's going to be your obligation to make the monthly loan payments. And all of the documents that you're going to execute in order to move forward with the transaction in acquiring property subject to the existing loans are going to have a requirement in them that you're going to pay those existing loans. And if you don't pay those existing loans, then the seller of the property, or if you do a long-term lease, the landlord would have the right to basically terminate those documents and either foreclose, do a forfeiture on an agreement for sale, or do an eviction on a lease and come back in and take over the property, and you're out. And so you want to make sure that you have clauses, though, in the documents that protect you from situations where you unknowingly fail to perform by not making the requisite required or the required payments under the existing loans. And what I mean by that is you want a clause in your subject to documents, purchase documents, which basically state that the seller or the landlord is responsible for providing you with updated information as they receive it from the lender as to the amount of the mortgage payment. So mortgage payments can adjust mainly due to an increase in taxes and insurance. And when those adjust, if the notice of the adjustment goes to the original or the borrower, and they don't give you the information, well, you're going to continue to make the same payment. Well, your payment's short, and you're technically in breach or default under the documents that you've executed, which then gives the borrower or the prior owner of the property the ability to come in and say, okay, we're done. I'm terminating your contract, or I'm going to foreclose, or I'm going to cause a forfeiture under an agreement for sale because you haven't made the requisite payments. So you want to basically put the burden back on to that party to say, okay, well, if that's going to be my obligation to make these payments, your obligation is if you receive information from the lender as to an adjustment in the amount, or you receive information from the lender as to a change in servicing, so you have to make a payment to a new company, and you have new addresses for the payments, those types of things, that you say, okay, that's fine. But if you receive this information, then you're going to pass that on to me. And if you don't pass it on to me, then I can't be in default, and it's your fault. It's your responsibility. And I'm still performing because I'm paying as agreed based upon the information that I presently have. And it was your duty to make sure to update me with any new information. So you want to make sure you have a clause in your subject to documents that basically puts the responsibility to provide information regarding any change in the loan payment, any change in the address where payments are to be made, any change in the name of the servicer where payments are to be made. You put those in there and you put that burden on the borrower former owner of the property.
Sean, this sounds a lot to me like a typical clause you would see in these agreements, the cooperation clause. And you see that in a lot of these agreements. Why isn't, in your opinion, just a standard cooperation clause not sufficient? And I take from your legal update that you want a separate provision that deals with this specifically. Why is not just a standard cooperation clause going to be sufficient?
Yeah, the reason why a standard cooperation clause isn't sufficient is that the cooperation clause basically says that the parties are going to cooperate with each other to execute further documents. It could also say provide information that is necessary for the parties to carry out the terms of the transaction, and that clause survives the closing of the transaction. So if you add the term information in, that probably is sufficient. But I want something more specific dealing with, hey, if you get information from the lender, you have a duty to timely provide that information. I, as the buyer, should not have to go and reach out to you and say, have you received any information? What information do you have? You know, those types of things. So I want something expressly stated so that if there ever is an issue, you can go straight to this, contractual provision and say, look, it's right in here that should you receive any information from the lender, that you have to immediately provide that information to me as the buyer by mail and email. You have to do both. And if you don't, then you're in breach of the documents, and I can't be held in breach because your prior breach basically forgives my subsequent breach of the documents.
All right. Thank you for the legal update, Sean. Let's get into a little bit of in-rem news, upcoming events. Let's talk about the Creative Finance Symposium. We just had one last week regarding the due on sale clause. And Sean, why don't you give our listeners an idea about what we're doing with the Creative Finance Symposium and how they can get involved?
Yeah, so every other Thursday we do the Creative Finance Symposium. It's from 6 to 7 p.m. Arizona time. So right now we're on Mountain Standard Time. So it'd be 6 to 7 p.m. Mountain Standard Time. So our next one is the 23rd. And the one that we had last week, we went over the due on sale clause. We talked about some strategies that on how to purchase property or acquire property. I shouldn't say purchase because it's really acquiring property, subject to using the state purchase contract forms and not violating the due on sale clause at the same time. And so we went over that strategy and how to employ that and how to utilize that strategy. This is a live event, and to receive the content from the event, to be able to show up and ask us questions in the last 30 minutes of the symposium, we open it up. We allow any questions to be asked of us regarding creative finance and, frankly, anything regarding real estate, if you want to ask us. And you can, we have that question and answer time. But in order to participate, in order to ask questions, in order to receive the content, you have to register and attend the event. We don't make it available online. In fact, I've already received requests on social media like, hey, is there a recording? Because we weren't able to make it. Well, sorry, no, there isn't. But good news is it's every other Thursday. So come March 23rd, you will have another Creative Finance Symposium from 6 to 7 p.m. Mountain Standard Time. You'll see links posted in social media leading up to the event. You just click on the link, you register, and you attend at the set time. But you have to attend to receive the content. We're not making videos available online. We're not, rebroadcasting, reposting the content. If you want to participate and receive the content, you have to register and attend at the time of the event.
All right. Thank you for that. With that, we're going to go ahead and get into our topic today. We're talking about HOA restrictions on short-term rentals. Our last show, we spent a good bit with Andrew LeBaron about how to manage a short-term rental. Today, we're going to get into some of the sticky situations the short-term rentals run into with HOAs, as in many states and in many areas, oftentimes, in fact, probably one could argue most of the time, a short-term rental is sits within an HOA, a homeowners association. So we're going to get into that today. And with us today to discuss the topic, we have two attorneys, Brian Locker and Jeff Johnson. Brian Locker is an attorney with the law firm of Fowler St. Clair. Brian, thanks for joining us.
Thanks for having me.
Yeah, we appreciate you taking the time to go through restrictions on HOAs or HOA restrictions on short-term rentals. Tell our listeners about you, about your practice, the firm you're with, and the state you're licensed to practice in.
Yeah, so I'm a partner at the law firm of Fowler St. Clair. And I'm licensed in both Arizona and Georgia. Started my practice in Arizona with Sean and yourself back in 2011, and in 2017 moved to Georgia, became licensed in Georgia, and I currently represent primarily real estate investors in both Arizona and Georgia on litigation issues, and also HOA issues that may come up, like what we're talking today.
Awesome, thanks. Also with us today, we have another attorney, litigation attorney with Fowler St. Clair, Jeff Johnson. Jeff, thanks so much for being with us.
Good to be here.
Yeah, so if you would tell our listeners a little bit about you, your practice, where you're licensed, what you do.
I'm licensed in South Carolina and Georgia. I practice out of Statesboro, Georgia. I'm a senior associate with Fowler St. Clair, and I'm in civil litigation, which includes commercial litigation, real estate litigation, and personal injury. Those are the primary areas.
Yes. Well, we appreciate you being with us. So let's dive into the discussion today. And we're talking about HOAs and we're talking about short-term rentals. Let's kind of start at the beginning and lay some foundation, lay some of the groundwork so that the listener understands, one, what we're dealing with when it comes to a homeowners association. So I'm going to just pose this. I'm going to pose this to really both of you, but for the sake of order, I'll ask it to Brian first and let you kind of all weigh in. But if in case there's anybody out there that's listening that doesn't know this, what is a homeowners association and why should we kind of on a fundamental level be worried about it? And Brian, I'll throw this to you, throw it to both of you, but let you kind of address this first.
Yeah, so at its most basic element, an HOA is just a group of homeowners or landowners who get together and decide to and agree on certain things that govern those group of homes. So it's in the name, right? Association. And so that can be as simple as just very basic, things that everybody agrees about in terms of, what they're doing. Maybe there's a shared road that the owners need to decide to maintain together, and it could be as comprehensive as a large planned community where that many people are familiar with, where you have very detailed rules and restrictions on things as simple as the color of your house and the type of grass you can plant.
So we're in Arizona now, and Brian, you're an Arizona attorney, and so a lot of folks that are listening here are obviously from Arizona and familiar what they know to be or what a homeowners association looks like here in Arizona. Jeff, I'm going to throw this to you. You heard what Brian said about homeowners association. Is it any different in Georgia, or is it pretty standard in terms of how homeowners associations work there in Georgia?
The essentials are the same. Not every home is going to be part of of an HOA. I would, just based on what I've seen, I think Arizona probably has more HOAs than Georgia, but certainly Georgia's got its fair share. I think when you're in the smaller towns, more rural areas, you're more likely to have a house that's not part of an HOA. But HOA is just, think, planned community. All the houses, the owners have associated together to do just what Brian said: regulate the community, the appearance, the maintenance of common areas, which would include roads. And then you have a lot of HOAs that have common recreational areas like a pool, a clubhouse, could be, a golf course, any number of things. And so they agree to share costs and ownership of that, as well as rules and regulations that everybody's got to abide by. As Brian was saying, the color of your house and what you can keep in your front yard, and how much time you have to roll the trash can back to the house after it's picked up. It can get really detailed.
So let's talk about the rules specifically. Do HOAs, and you just mentioned them, homeowners associations do have rules that must be followed. Brian, give us an idea about kind of the rules that a homeowner would be expected to see in a typical homeowners association.
So if you're purchasing a home in a planned community, that is incredibly common in the Phoenix or Tucson metropolitan area, maybe in the Atlanta metropolitan area, it's going to cover your basics. So typically you'll have some sort of a design review committee. So if you want to alter the physical appearance of your home, you're going to have to get clearance for that. It's going to deal with the common maintenance. So things like Jeff was mentioning, so a community pool, a clubhouse, that sort of a thing, especially where I live in Marietta, Georgia, that's very common. Pretty much every community has a pool and a clubhouse in the suburbs. And so you'll see that's going to be very common. Road maintenance, trash, all of those things are going to be, the stuff that you're in every planned community is probably going to be addressed in one way or another.
So let's talk specifically now about the short-term renter, the person who wants to rent their home by Airbnb, by VRBO. They want to use it as kind of a quote-unquote vacation rental or short-term rental, something that is not your typical long-term year rental, something very short. Just a simple question: can an owner who wants to do that, can they do that in an HOA?
The answer is yes, unless it is restricted by these governing documents, the CCNRs, the declaration, those types of things. Those are the documents that can potentially limit a homeowner's ability to rent for a shorter period of time. So these other things we were talking about, the physical changes to your property that might need review and that sort of thing. The other main thing that can be restricted potentially is the ability to rent for particular periods of time.
So going to your kind of previous description of a homeowners association, it really is a private cooperative, so to speak, of private persons that have formed this. I think a lot of people, a lot of the times, confuse that, because there's rules and regulations associated with it. They confuse that to be laws passed by governments and things like that. How do HOA regulations differ from, let's say, municipal regulations?
So the main difference is in Arizona, and I imagine most states, is that an HOA and the CCNRs, the restrictions that are in an HOA, are governed by contract principles, right? So Andy, if I contract with you to purchase your house, right? We have an agreement, and the terms of that contract and how I'm going to purchase your house are contained in this purchase contract, right? Well, the CCNRs, people don't really think about it this way, but the law treats those CCNR documents the same way, and except it instead of there being two people, a buyer and a seller, you just have in some cases, many people all contracting together and deciding what are the terms upon which we are all going to live together in a community. And so that is, from a legal standpoint, how the law views an HOA, that's different than regulations that are passed by a state legislature or a local municipality. That's not a contract. That's an imposition of law, and the way that that's regulated and the way laws are passed obviously are very different than the way CC&Rs operate. It's a much more macro versus micro level governance.
Jeff, is that distinction in Georgia pretty much the same, whereas homeowners associations essentially govern and regulate each other within the association by virtue of contracts, recorded CC&Rs, and is that how that really differs from municipal regulations, laws, and ordinances passed in whatever city in Georgia?
Yeah, it works the same way. And you can have something that's a violation of a municipal ordinance, and it might also be a violation of your community CC&Rs. Think about like a noise violation. All right, whatever city you live in probably has a noise ordinance. And there's a good chance that in your CC&Rs, your covenants, conditions, and restrictions for your HOA, they probably got something about excessive noise too. So you might get a notice of violation from your HOA, even though the police were never called out to your home. And then they say, all right, you have to pay this fine because on March the 9th at 10 p.m., you were too loud. But it's arising out of contract. So if you don't pay the fine, they can roll it in to whatever you owe the HOA for your dues. And then if you end up still not paying it, they could potentially place a lien on your house to collect it, or go to court and sue you for breach of contract, whatever other legal remedies they might have. But it's not like a criminal offense, but it's still binding in the sense that if you violate it, they can bring an action against you. Just like Brian was saying, if you violate any other contract, you could be sued for your breach.
So let's talk now about short-term rentals specifically. And short-term rentals, really the industry of short-term rentals has been a booming one. I think in probably the last 5 to 10 years, we've seen it go from kind of this niche idea to one of kind of the preferred methods of residential real estate investing, if you're able to create the right experience with your property, if you're able to create the right kind of market, real estate investors are finding a lot of value with it. But with every growing industry comes problems, comes issues, comes things that neighbors maybe never thought of with regard to what it would be like to have a short-term rental within a neighborhood. That provides struggles for municipalities on how to regulate that, and that provides obviously struggles within homeowners associations on how they regulate that. So in your view, we'll start with you, Brian, in Arizona, how are HOAs presently viewing short-term rentals? What's that relationship look like kind of right now, generally in Arizona with HOAs and with the real estate investors that are doing short-term rentals?
So I would say that the general consensus, at least in my experience, is somewhat adversarial. And I think it depends on where you're talking about, right? Because I think depending on the community, there can be more understanding within a community that short-term rentals are going to be going on. So if you're in a higher tourist area, right? So let's say you're in Central Scottsdale by Old Town, right? The owners down there likely expect that there's going to be more tourism and so more transiency, more short-term rentals, that sort of a thing. So maybe it's less adversarial in areas like that. But as you move out into the suburbs, out into East Mesa, up into Glendale, places like that, the adversarial nature sort of increases because you have people who said, look, I moved here to live here and raise a family, and now I've got, parties, bachelorette parties and whatever, that are sort of disturbing what I believe to be the character of the neighborhood. And so that's where sort of the resistance comes in, and where people who are trying to short-term rent their property run into roadblocks.
Jeff, how about you?
Brian,
Sorry, Sean, you have a question? Go ahead.
yeah, so I just wanted to follow up on that. So obviously, our firm represents a lot of investors, and a lot of our investor clients who have short-term rentals actually will say that the best occupants of the property are the short-term rentals. Is the long-term tenants that are the disaster, and create all the problems and destroy the unit and whatever. But it's the short-term renters that keep everything spick and span and leave it the same way that they entered it, and that type of thing. Do you think there's like would like education or anything go a ways to kind of solving some of the fears that these HOAs have regarding short-term rentals in their community? Because it seems like it's more fear than actual reality, if you will.
Yeah, I think there's a good case to be made for that. I in the cases that we're involved with short-term rentals and HOAs, what we see is the HOA, there's a vocal minority of people in the community who have had bad experiences with short-term renters. And so they are the ones who spend the time and the effort to put a bug in the ear of the boards that control the regulations. And the board, as with many organizations, the governing body is going to often, if you don't have strong leadership, is going to sort of be swayed by this vocal minority, whether or not it's the general consensus or opinion in the community. And so, yeah, Sean, I think to address your question directly, yeah, I think education could absolutely be helpful, because what we see is that there is sort of education on the other side that goes on in the form of what I consider to be propaganda in most cases, where it's like, look, short-term renters are going to destroy the character of your neighborhood, and it's just going to be party central on your street. And when in reality, they're using the exception, sort of the bad apple that ruins the bunch, sort of logical fallacy to advocate for their position.
Jeff, what about in Georgia? What's the relationship been like, as far as you can tell, between the homeowners associations there and the short-term renters?
Yeah, I think the general principles are the same. And I really think it depends on like where the HOA is located as to whether the neighbors are going to have kind of this predisposition to be against short-term rentals. Because if you think about like a community that's on a lake, a lot of the people that are going to be coming in and staying on a short-term basis probably are going to be younger. They're there because they're on vacation. Maybe they do want to get out in the backyard and grill out and have a beer and get loud. And maybe the house next door that has permanent residents or semi-permanent residents, they're an older retired couple and they just want it to be quiet. And then you have other HOAs where who's coming in to rent the property, and how likely is it that they're going to be using it in a way that disturbs the neighbors. But like Brian was saying, at least with short-term rentals, if you got a bad renter, they're going to be gone after the weekend. That's a lot better than having a neighbor that's there on a permanent basis that's just a jerk, and you're going to have to deal with them no matter what. So I don't know that anything's been established that, as a general rule, short-term rentals are more problematic than long-term. But it's one of those, your mileage may vary situations. So if you're somebody that's had a bad experience once or twice with short-term renters next door, you're probably more likely going to be opposed to that idea, and you want to see your neighborhood be more permanent.
And just to expand on that point, we work with short-term rental management companies in some cases, and they are actually implementing technology to reduce sort of the problems of these, loud, boisterous, what neighbors would consider annoying tenants, to the point where they're actually installing noise sensors inside and outside the homes, cameras on the front of the homes to see who's coming and going, and to provide for real-time monitoring. They are reaching out and informing neighbors of who they can contact if there are problems, things that you just don't see in long-term rental situations, where neighbors have the ability to address issues as they come up, in a way that's going to actually make a difference and actually resolve the issue without having to get an HOA involved, get law enforcement involved, as the case may be. So,
As a homeowners association, one of the legal issues that I think is there, you mentioned that this is a matter in a relationship that's governed by a contract. But a lot of homeowners associations out there weren't formed yesterday. Um, Most of them and many of them were formed decades ago. So the governing contract of the homeowners association, of the people that live there, may be decades old, and oftentimes is decades old. Old enough to where they likely didn't even contemplate short-term rentals at all. So, assuming that to be the case, what are homeowners associations doing now, and what can they do in order to combat or address what they're trying to address when their rules or their original CC&Rs didn't even address it? What kind of power do they have in that case?
yeah, let me clarify the point you were making there. So short-term renting has always existed, right? We just called it by a different name, right? You would consider a bed and breakfast, right? The idea that you would go into someone's home and stay for 1, 2, 3, a short term, like you would in a hotel, but have the comfort of a home, and oftentimes the owner would still be there, right, and even cook you breakfast and things like that. That has sort of shifted, right, over time into this much more formalized and commoditized type of industry, because we have the internet now, and we have platforms like Airbnb, HomeAway, VRBO, these huge marketplaces where people can literally create an account and list their property or a portion of their property for rent by themselves, and have instantly millions of people be able to find them, right? That part of the industry didn't exist. And to your point, HOAs have had to adapt. And so how do they adapt? They adapt, and historically what they did originally is they just adopted rules, right? And so if you had an HOA that didn't want to have short-term rentals in their community, they would simply amend their bylaws. And so in an HOA, you will have your primary governing document, the CC&Rs, the covenants and restrictions, right? And that is a recorded document. That is your contract, like we were talking about earlier, right? To amend that, you have to amend it in the same way you would amend any contract, right? And that could be provided for in the document itself, or if not, then Arizona law or the state in which you're residing would govern how that needs to be amended. But bylaws are also in most HOAs, and bylaws are just a set of rules in a document that the HOA or a board that's appointed by the HOA just decides to adopt by, some sort of resolution, right? And so the way that what we saw originally occur is, all right, well, we just got to put a stop to this, so let's just adopt a resolution that their rentals can't be for longer than or can't be shorter than a certain period of time, right? And so that they would do that, and in Arizona, that was curtailed by legislation that basically said, look, if you're going to regulate a rental, you can't do it by just adopting a resolution by the board. It needs to be more than that, because an owner's ability to rent a property is a fundamental right of property ownership. It's something that should be and is protected in not just in Arizona, but in the United States, right? The idea of real estate ownership and property rights are a fundamental right, and you can't just curtail those by fiat, right? There has to be some sort of democratization of that, and so in Arizona, that's how they addressed it: is okay, you can't just pass a bylaw, you got to amend the CCNRs. And so what you've seen over the last decade or so are these older HOAs have to go back and amend their CCNRs to, if these communities decide they want to restrict, they have to go through. And what HOAs are discovering are oftentimes, to amend the HOA, the documents, the CCNRs, made it very difficult to do that for good reason. But they're finding, sometimes you need like 75% of the people in a community to all agree to create this restriction. Well, if anybody, who's engaged in any sort of politics knows, you probably can't get 75% of people to agree that the sky is blue on a good day.
Yeah. Just to give the context to the listener, to amend a deal is simply just the agreement of all of the parties to the deal to amend it. Well, usually the parties to a deal are two people. The parties to a deal in a homeowners association could be thousands of people, and the CCNRs have set forth how that goes about. And to your point, if you have to get 75% of 1,000 people just to amend, I mean, the United States has not been able to amend its own constitution for forever just because how difficult it is. The same kind of principle applies, right?
Absolutely. Yeah. And so that's the issue that HOAs are having, is how do we address this industry that frankly didn't exist, 15 years ago in the way that it exists now. And so they are employing creative solutions in some cases to do this and to restrict short-term rentals.
Hey, Brian, question for you. Let's just say hypothetically that I've bought a property within a community. I did my due diligence. I reviewed the CCNRs. I reviewed all the rules and regulations. I did everything. And there was nothing in the CCNRs about short-term rentals. Or I shouldn't say nothing about, just no prohibition on short-term rentals. Like, there was no time limit or anything. No restrictions on leasing the property, nothing like that. And I'm like, oh, great, I'm going to use it as a short-term rental. And so let's say I was early in the game of short-term rentals. And, for the last 5 years, I've been renting my property as a short-term rental. I'm doing well financially, making a lot of money from it, better than, say, putting a long-term tenant in there. And then all of a sudden, like you said, you get the loud minority that goes around and somehow manages to trump up the necessary owners to sign an amendment to the CCNRs. And then now the association comes to me and says, guess what? Yes, you've been doing so well with your short-term rental for the last 5 years. And yes, when you bought in here, you did everything right. But guess what? We're changing. You're out of luck, and you can't use your property as a short-term rental anymore. Do I have any recourse?
So that is a hot topic in Arizona, and that is the subject of significant litigation currently in the courts in Arizona, because what you're talking about legally is the idea of what can you do as a party to a contract without the permission of certain other parties to the contract, right? And so, because presumably, if I'm someone who is short-term renting my property, I'm not going to sign off on a change to our contract that says I can no longer short-term rent my property. So, why is it that the other members of this contract can impose this restriction if it didn't previously exist, Sean, like it was used in your example? So oftentimes what HOAs are pointing to here are the amendment provisions. Like, look, you signed on, and in our contract, it says that if enough of us get together and decide to change it, we can, right? And the pushback that we're getting, and the pushback that on that argument is that, okay, yes, but our contract in the context of a community created a certain character and an expectation, right? I went into this contract with certain expectations about the nature of this community and what it was. And when I signed on, the nature of this community included my ability to freely rent my property however I want. And you are changing the very nature of my community. My community, by this change, no longer looks like the one that I agreed to. So you're actually changing the fundamental contract that I agreed to when I purchased the property. So that is the pushback and the tension that the courts are trying to address is, at what point have you changed the deal? At what point have you changed the contract? You're no longer just amending the contract and abiding by the terms, and you just, too bad, so sad. You now have changed the actual bargain that I agreed to. And what is that point? And so that's what's being decided. And it's a real problem, because if I'm going to spend, in Arizona, you're going to spend $750,000, $1 million for a property for the purposes of maybe living in part-time, but then short-term renting the rest of the time. If all of a sudden I can no longer short-term rent, I may not be able to afford that property anymore. That may have been part of my, the way that I could even have afforded to have this property. And so, can the community impose this on me, which is effectively going to force me to sell my property? And so that's what the courts are in Arizona, at least, are trying to figure out.
So they're trying to answer this question about what facts change the very nature of the bargain to begin with, such that you shouldn't be able to just regulate that by passing rules without amending the CCNRs. What is the settled case law to date in Arizona? In other words, what in your mind is not really in dispute in that regard? Is the question about whether you need to amend the CCNRs, is that settled, or is there still a question about how far you can go with the rules and regulations? I guess that's my question.
Yeah, in Arizona, that's no longer a question. In order to restrict rental activity, you have to actually amend your contract, amend the CCNRs. So that's not in question. What is in question is, okay, so now we've amended the CCNRs. Is that amendment even valid? Because not every amendment to a CCNR is valid, right? We can't go if a majority of the homeowners tomorrow in a community decided that they were going to impose an additional fee of $10,000 a year for some big project that they wanted to do. They want to create a golf club or something, right? Well, just because you pass the amendment doesn't mean that you can fundamentally change the character of this particular community by imposing this massive additional fee on everybody in the community. So that's where the push comes in, is yes, everybody agrees you have to amend the CCNRs in order to impose short-term rental restrictions. But can you even impose that short-term rental restriction in that particular community at all? That's the question that's being answered.
So,
Jeff,
Brian, and maybe if Jeff wants to jump in and answer this as well, but I have a little bit of knowledge of the case law on, the ability of an association to amend and change the character of the community and that type of thing. And there's this thing called the blue pencil rule. and we see the blue pencil rule laid out in covenants not to compete. So if you put a covenant not to compete in somebody's employment contract, and you go too far with that covenant, you say, oh, you can't compete with me for 10 years after you're terminated. The court's going to look at that and say, oh, 10 years is unreasonable. That's outside the scope of reasonableness. And because of that, I'm going to I'm going to blue pencil that. Well, in order for a restrictive covenant to be enforceable, it has to have the length of time. And so when the court blue pencils it, that basically means it eliminates the restrictive covenant. It does not mean that the court can amend. The court has no power to amend. It just can blue pencil. So it can't go and amend the restrictive covenant to make it reasonable. Now, how does that work with our courts and CC&Rs? Because I think the court has used a blue pencil rule, or our Supreme Court used the blue pencil rule on some CC&Rs that an association passed that it deemed were invalid or unreasonable, or changed improperly tried to change the nature of the use of the property or the character of the community. What would that look like as far as, the court using the blue pencil rule on CC&Rs?
Yeah, Jeff, I'll let you take that one.
Arizona, you've got the recent Supreme Court case decided last year of Cowway v. Calabria Ranch. That dealt with the very issue that we're talking about here, which is a homeowners association that decided to pass CC&R amendments. In that case, it wasn't specifically about short-term rental, but it was about other property usages. And the affected homeowners challenged it. It went all the way up to the Arizona Supreme Court. And what the Arizona Supreme Court did is it decided that it was going to strike or blue pencil provisions in the amendments that were not reasonable or foreseeable based on the original declaration. And that's the situation, Sean, that you were talking about, where as a buyer, you look at the CC&Rs before you buy, and you say, okay, I'm allowed to do this, this, and this. You buy your property based on that understanding and you rely on it. And then later, the homeowners decide they want to change it. The Supreme Court decided if it's outside the scope of what you are on notice of when you purchase that property, if it's not foreseeable, then we're going to blue pencil that. And the court went through various restrictions, such as they had added restrictions on how big your garage could be compared to the size of the living space in your home. And so it went through and it line by line struck those provisions that it decided were not foreseeable based on the original declaration.
So by blue penciling, it sounds like the court did not just grandfather in prior owners and prior uses and say, well, they weren't on notice, or they started using their property prior to this change or amendment. So for them, they can continue to use it this way. But for future homeowners, oh, well, the amendment can stand. If I understand correctly, by blue penciling it, it means it's out of the document. Like, it's not going to be enforceable on anybody. It's not like we're just grandfathering somebody in and saying, oh, well, okay, homeowner, you filed a lawsuit. You can continue because you were using it before the amendment. But any future person, well, in theory, they had notice because the amendment existed when they bought their property, so they would know. So my understanding, the significance of the blue pencil would be that the court's striking it. And so, hey, guess what, association? You were unreasonable, so we're going to strike it, and it's not valid for anybody. Is that kind of your understanding?
Is that the way you read it, Brian? Because in theory, as for future homeowners, the association should be able to amend the CC&Rs any way that they want, so long as it doesn't violate some other provision of law, right? Like, so if we want to keep future people from building a garage that's bigger than X, like you're saying, that would be fair to them because they haven't bought the property yet. They would be taking it subject to the CC&Rs. If they don't like that provision, they don't have to buy the property. Whereas somebody that's already bought, they had one understanding coming in. Now you're trying to change it.
Yeah, I mean, if homeowners associations,
Yeah, but see, that's the thing, that this HOA or the
go ahead, Sean.
go ahead. Well, so here the thing is, when I read that case, I see the Supreme Court as having two options. One is to allow the use for the old owners, or the other is to blue pencil it, to get rid of it, to strike it. It's not in the document anymore. To me, that's the Supreme Court's use of the blue pencil rule. To me, is the court saying, "Hey, HOA, think twice before you pass an amendment that you know is out of bounds. Because if you do, you're going to go through all this time, expense, effort, and guess what? We're not going to just grandfather people in. We're going to strike this sucker. And when we strike it, you're out. Like, you don't even get to use it for future homeowners. So tread lightly, HOA, tread lightly, because we're going to strike this thing. And you're going to have nothing. You're going to, you'll have nothing going forward. And you've spent money on lawyers, and you've spent, money on maybe marketing firms to get this thing passed. And you've spent a bunch of time, with your propaganda and whatever. And guess what? We used the blue pencil. We didn't just grandfather people in. We used the blue pencil and struck it. And it's no longer in the document. I mean, that's what I see when I read that case and think of them using the blue pencil rule as opposed to simply, they could have just said, oh, yeah, old homeowner, you get to continue to use your property. But if you ever sell it, then, the future owner is bound by the amendment. That's not what the court did. They struck it. They blue penciled it.
Yeah, I mean, parties are spending hundreds of thousands of dollars every time this thing goes up and is challenged, especially in larger communities. And so, look, at the end of the day, these HOAs are insured. And when a homeowner challenges a provision or an amendment to CCNRs, it likely triggers coverage. And so the HOA doesn't have to feel it right away, because a carrier is going to be paying for the lawyer's fees. And so that sort of creates a disincentive to actually craft amendments that, maybe, Sean, to your point, are a little more tailored and likely to pass legal muster, right? Because if they were to take a rental restriction amendment and say, we're going to pass this, but it only applies to people who purchase properties in this home after the recording of this amendment, I don't see how on earth that would be unlawful, regardless of what's in the contract, right? Because the court is going to do an analysis of what was foreseeable in the contract, right? But if you're not even applying it to the people who are members of the contract at the time of the amendment, and it's only to future owners, then the foreseeability issue is out the window, because it's going to be foreseeable to everybody who purchases after the recording. But HOAs don't want to do that.
Right. Yeah. And to your point, that's the balance, right? That's kind of the check and balance of the blue pencil rule, which is, if you're going to make something overly broad, we're going to take it out entirely, as opposed to, we're not going to revise it for you. We're not going to narrowly tailor it and add the language that you just suggested, Brian, and say, oh, but for future homeowners, this applies. So, you could have done that on the front end. You chose not to. We'll fix it. We'll make it right. The court's not doing that. They're actually striking the language, as opposed to your point, Brian, rewriting it to say, well, it'll apply to future homeowners. That makes sense.
They're not doing it because that doesn't appease the vocal minority that created the issue in the first place, right? They want a change now. They want this to be resolved now. And they're not going to be the one that moves. They're going to make sure that the community resembles, what their idea of the community should look like. And if the HOA were to be more, in my view, responsible, or conservative about this, and and more risk averse in the passage of their amendments, you wouldn't have nearly as much litigation on these issues as you do. But if you were to ask an HOA attorney why that isn't the case, it's because in their view, they're put between a rock and a hard place. In their view, they're either going to have to defend a case by the homeowners, by the renters, who are going to challenge the validity of the amendment, or they're going to be sued by this vocal minority for failing to properly enforce the restrictions that are out there. And in conversations that I've had with HOA attorneys, what they basically say is, we're simply making the choice of picking the fight with the renters and not with the vocal minority, and that's just the decision they've made.
So Arizona's at a crossroads, so to speak, on this question or these questions. Is Arizona, in your research, among the first states to have to deal with this, or is there examples we can glean from other states that have already addressed this, or will all this other states in the future be looking to Arizona on how they kind of resolve this?
I mean, my guess is many states will be looking to Arizona. I have to imagine that states like Florida and California, and other tourist-heavy states also deal with this. I haven't done a ton of research into sort of whether those issues are being addressed in the courts, and whether the same issues that Arizona is dealing with are being litigated up to the appeals and Supreme Courts of these various states. But yeah, I mean, certainly it's interesting, and I've actually had discussions with some of the corporate attorneys at platforms like Airbnb and VRBO. They are looking at these things and are interested, right? Because one of the cases that we're handling is a very large community where we represent some short-term renters, like 3,000 homes. And for Airbnb, that represents a substantial amount of revenue for them, right? Because if you've got 100 homes in that community that are short-term renting on your platform, and these homes are getting $600 to $1,000 a night because these are nice homes, that represents a fair bit of money in Airbnb's pocket, or in the case of a rental restriction, a whole bunch of money out of Airbnb's pocket. And so they are looking at this, and they have actually reached out to us to, because they're interested in looking at what's happening.
Jeff, from Georgia, but not just specifically as to Georgia, in any of your research, have you seen other states that have addressed this or resolved kind of these same questions Arizona is facing, or does Arizona look like they're kind of first to deal with this issue?
They're not the only one. I couldn't give you a rundown state by state, but I could tell you Texas, for example, has got a decision that kind of leans the other way from Arizona's Callaway case. Now, Arizona had some case law prior to Callaway that really articulated the same principle. So it wasn't that Callaway was breaking new ground, so to speak, but it was making it much even clearer that in Arizona you can't add new stuff that's outside of people's expectations. Whereas, like in Texas, I don't know the name of the case, but they're a little bit more lax in what an HOA can do in amending its CC&Rs. So it's going to vary a little bit state by state, but that's going to depend in part on what that state's case law was like regarding CC&Rs and the contract principles that apply to them.
That being said, what I will say is that Arizona is not unusual in its contract law, and so long as your state recognizes general contract principles and that the contract principles apply to CC&Rs, then you're likely going to see a similar result. And obviously, there's a lot of shades of gray there in how exactly that's imposed and that sort of a thing. But Arizona's not an outlier. They just happen to be, one of the larger states in terms of tourism and that sort of a thing. And so you're seeing it there.
Well, Brian and Jeff, we really appreciate you taking the time to be with us today to talk about this. Brian, why don't you tell our listeners how they can connect with you if they've got a question about Arizona issues or Georgia issues, as the case may be? How can they connect with you?
So the best way to connect with me is to go to fowlerstclair.com, and you can schedule a consult to meet with me. If you have a real estate issue in either Arizona or Georgia, I'd be happy to meet with you about that. And so that's probably the best way to get hold of me.
And Jeff, we appreciate you being with us as well. Tell our listeners how they can connect with you.
If you want to email me, you can email me at johnson@fowlerstclair.com. You can also find me on the Fowler St. Clair website.
All right. With that, thank you guys so much for being with us. We appreciate it. Good topic, important topic. If you're watching, make sure to be with us next week. We're talking about structuring insurance and a subject to transaction. We're devoting an entire episode to it. And our guest will be insurance agent Mike Monzingo. Again, we're talking about insurance and a subject to transaction. Don't miss it. It'll be a good episode. We'll see you next week.
Have a good day, everyone.